everybody? Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Want to remind everybody, hit that like, share, and subscribe button. There's a PayPal link down there in the details section for anybody who wants to share some love. All is certainly appreciated. And the StreamYard link is there for anybody that wants to join the panel. Tonight we're going to talk about probate, the exceptions, and what it is and how it works. And this is in relations to anything that they're trying to do in these courts or any kind of applications or anything where you're not fully conscious of what's actually going on. You're actually putting forth an implied contract. That's the main presumption. So let's take a look at it. And what I've got here is LII-WEX, again, Cornell Law School, probate. Probate is a judicial proceeding by which a testamentary document is established to be a valid will. So the court of probate can't administrate somebody's estate without having a will. What happens, though, is if they find a property that doesn't have a will, it's called abandoned, and therefore they take a duty of care as to fraud, waste, and abuse to make sure that they make an attempt to get it to its rightful heirs. A weak attempt, but it is what it is. And it goes on to say, upon legal recognition being granted to the will or other document. Being granted to the will or other document upon legal recognition. This is upon legal recognition, the enumeration at birth, there's a legal recognition in accordance with an other document. A probate court will appoint an executor to administer the estate of the deceased and distribute assets to the intended beneficiaries. If a person dies intestate without a valid will, the probate court will distribute the decedent's estate according to state law. So one of the prerequisites, one of the minimum standards, is that a person has to die first and foremost. And then there's the consideration of the will, testate will or intestate will. A will would be a valid will, which would be a testamentary document is available. If without the testamentary document, it's called intestate, which actually means away from testate. Without a valid will, the probate court will distribute the decedent's estate according to state law. Unless set aside, the probate of will is conclusive upon the parties to the proceedings and others who had notice of the proceedings on all questions of testamentary capacity. This goes to the Scott versus McNeil. They have no right in any case, in any jurisdiction, to appoint anybody to administrate the property of the estate of somebody who is in fact alive. That is up to them and their will. And just because you don't have evidence of it isn't some kind of presumption that you can, which is exactly the presumption they lay when they make a claim, is that there's some kind of contract at play. And if you don't respond, then default judgment is placed against you, saying that there must be a contract. The absence of fraud or undue influence. Undue influence is what we're talking about, and due execution of the will. Probate does not preclude inquiry into the validity of the will's provisions or on their proper construction or legal effect. New York's SCPA Section 1408 requires that a probate court inquire particularly into all the facts and must be satisfied with the genuineness of the will and the validity of its execution before assets can be distributed. So when a third-party debt collector comes after your estate for its assets as a claim of a loss, and therefore they want $4,118 and some odd cents, and they only paid $41 for the damn data elements, that's unjust enrichment, and asking the court to to distribute those assets upon execution of a valid will that doesn't exist. There's no contract and there's no will, then the court has nothing to administrate. It's all false. More generally, probate as an adjective. Remember I spoke about the adjective, the living will. Probate as an adjective can refer to all subjects that fall under the jurisdiction of probate courts. In other words, they have to prove that there is no will and that there's no will in regards to a deceased person. They can't claim, well, you're living, so you must have a living will. They can't say that, and they can't say that you must have a will. It's none of their business. The pure simple fact is they don't have the power to appoint an administrator to do anything with your private estate. There's no authority that allows them for that. The next one is the probate court is a court of limited jurisdiction that hears matters surrounding a person's death, not his life. You're not supposed to be coming and collecting that stuff until upon death, wherein then you can settle the estate matters and make sure all creditors are whole, making sure that that creditor is a valid creditor to the estate by making sure that there's a valid contract in play. If there's not, then they're making a false claim even after the death. Most frequently, probate courts oversee the distribution of decedents' assets according to their wills or other testamentary documents and direct the distribution of decedents' assets. Remember, they're directing it now. That's what's so important about a will and a living will. You get to do the directive. It's the importance of equity as a matter of judicial court. That's where equity resides. And remember, it was merged with common law. And this is why they have to prove that there's a contract. Otherwise, they're not operating as a court of record. If they die intestate without a will, those testamentary documents are the implied contracts that you've been signing all of your life, saying that was your will, to allow the courts and the state to administrate your estate. You became an authorized representative upon signing the SS5. Instead of taking and managing your own affairs of estate, you handed that over to the Social Security, and then they sent you a card as an authorized representative of the estate that you now authorized them to administrate. Without that, they wouldn't have that presumption. Well, I can't say that, because even without that, they take that presumption because they presume everybody is required to have ID. Everybody is required to have a Social Security account. Everybody's required to pay taxes. These are their presumptions, and they're false. Some probate courts also hear petitions to declare people incompetent and oversee guardians or conservators, while other jurisdictions, notice that's plural, leave these matters to family courts. See, you don't have any power to do so over somebody who is in fact alive. The issue still remains as to whether it is deceased or a living soul. Probate courts are governed by state and local law, and they derive their power and jurisdiction from statute. So a court of probate has no authority in equity or common law. It's by implication of statute as a contract itself, as a federal acquisition regulation. In some states, probate matters are handled by probate divisions of ordinary courts. Some jurisdictions refer to their probate courts as surrogate courts. Subrogation and abrogation as it relates to surrogation. Surrogate courts or orphans courts. For examples of state constitutions and statutes setting up probate courts, Alabama's Constitution, Article 6, Section 149, states that the legislature shall have power to establish in each country a court of probate with general jurisdiction of orphans' business. That's one term there. That's not just with general jurisdiction of orphans, but orphans' business. The estate, his private property, because he's an orphan and incompetent. And with power to grant letters testamentary. So it's the court of probate has the power to grant letters testamentary. How do you grant somebody's testimony? Are you trying to censor it? And of administration. And of administration. And of administration. You have to be subject to the administration first and foremost for anything else to happen. And that means you have to go through the judicial officer department to have the assessment done first as to the value within the supposed contract to be administrated or for administration. Provided that whenever any court having equity powers has taken jurisdiction of the settlement of any estate, it shall have power to do all things necessary for the settlement of such estate, including the appointment and removal of administrators, executors, guardians, and trustees, and including action upon the resignation of either of them. Oregon's Section 111.095 provides probate courts with full legal and equitable powers. So as it regards the legal estate, that's one power. But the equitable powers can again only be extended by he who has equity to make declaratory judgments, as provided in Oregon Revised Statutes 28.010 to 28.160, in all matters involved in the administration of an estate, including matters pertaining to the title of real property and ownership of personal property, the determination of heirship, and the distribution of the estate. Problem here. In all matters involving the administration of an estate, again, being a prejudicial determination saying that they have the right to administrate it because it's an estate in their property or their entitlements. Again, it's their person, folks. They're only managing your estate affairs. So as it relates to all the matters involved in the administration of an estate, including matters pertaining to blah, 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 the determination of heirship. That's the inheritance. The determination of inheritance and the distribution of the estate. We're going to talk about that here in a little bit when we look over the Iowa State probate. So the next one I've got, again from LII-WEX, is jurisdiction. Jurisdiction can be defined as the power of a court to adjudicate cases and issue orders. So the administrative courts have no powers to adjudicate any estate property whatsoever, despite their claim of all matters of administration of an estate, because again, it's dependent upon the one factor of a deceased person. When that one factor, the minimum standard, is not met because you are in fact living souls right before their very eyes. Therefore, it is a equity court because it's no longer subject to a contract that may or may not be there, but you're right to object to the fact that there isn't a contract. And that's your obligation. Objection: no valid contract pursuant to common law. Common law is the judicial nexus between equity and those actual contracts. If there's no actual contract, then they can't come with equity. He who seeks equity must come with equity. That proves they're not seeking equity. So what can you do? You can empower the court by fulfilling an intent to, or imputing an intent to fulfill an obligation. And that's merely correcting the record, which will show you that they're making false claims, have been making false claims, and those false claims resulted in false debts against the U.S. General Ledger. Territory within which a court or government agency may properly exercise its power. If they're seeking a judicial action in a suit of law and using an administrative court as if though they can avoid the judicial docket, that's the problem. The administrative court is an administrative docket pursuant to contracts, implied. And unless you object and take it to the proper judicial court, the judicial officer, the administrative law judge, and the Postal Service Board of Contract Appeals. That's the judicial officer department, a neutral and independent forum within the United States Postal Service. And it's the Postal Service that balances the general ledger. It's the Postal Service that specifically says, capital of the Postal Service shall consist of the equity of the government of the United States. Federal government means all entities of the government of the United States, including the United States Postal Service and the Postal Regulatory Commission. So let's get into the probate from Iowa. And we've got John with us. How you doing tonight, John? Greetings.
Hello. How you doing, Keith?
Good, good.
Yeah, is there, by any chance, do you think the application for the BC is a letter of administration?
It's maybe a budget letter or a budget of a beneficiary letter. It can be described as many things.
Okay, I'm just trying to nail how they're getting permission to start the probate process. You know, what specifically is doing it?
Well, it's the presumption that's laid by the burial trust that they have an obligation to a decedent that hasn't died yet. So they have to stay with that presumption to keep the contracts going, because otherwise they fail their fiduciary obligation under trust. And as long as nobody makes an objection as to the correction, then they're going to remain on that responsibility of the public trust. Say, well, we have to administrate it.
Right.
So let's continue on, because the next one is we're getting into the probate of Iowa code. Let me bring this up so everybody can see it. And you'll see one of the first things that they mention here is that Health and Human Services Code, 42 U.S. Code. It says, when used in this probate code, unless otherwise required by the text or the context or other subchapter of this probate code, the following words and phrases shall be construed as follows. Administrator means any person appointed by the court to administer an intestate estate. So as the administrator, known as the administrative law judge, if he is in fact administrating the estate of an intestate decedent. Watch him get all jiggled up by that. Assistance animal means an animal that qualifies as a reasonable accommodation under the Federal Fair Housing Act, 42 U.S. Code 3601. As amended, or Section 504 of the Federal Rehabilitation Act of 1973, 29 U.S. Code 794. That's the workforce labor. That's the labor laws. Assistive animal means a simian or other animal specially trained or in the process of being trained to assist a person with disability. Bequeath includes the word devise when used as a verb. Bequest includes the word devise when used as a noun. Charges includes costs of administration, funeral expenses. That's what funds that burial trust. Cost of monument and federal estate taxes. It's always going to be a tax issue, folks. Tax and insurance. Now, this is the part that really gets you. This is the exception we're talking about. Child includes an adopted child. An adopted child. No one else, just an adopted child. And then it goes on to say, but does not include a grandchild or other more remote descendant, such as a cousin or such and something, nor except, see where the exception is? When they use this term, except, as provided in section 633.221 and 633.222, a biological child. So the exception is a biological child, and under 633.221 and 633.222, it talks about the inheritance. Six three three point 633.221 biological child inherit from mother. Unless the child has been adopted, a biological child shall inherit from the child's biological mother, and she from the child. That's setting forth two witnesses on the maternal side. Again, you are the next of kin of your mother. The next one And you'll see it's got a little more verbiage. And again, it says, unless the child has been adopted. Unless a child has been adopted, a biological child shall inherit from the child's biological mother. And unless a child has been adopted, a biological child inherits from the child's biological father if the evidence proving paternity is available during the father's lifetime, or if the child has been recognized by the father as his child. But the recognition must have been general and not notorious or in writing. Under such circumstances, if the recognition has been mutual and the child has not been adopted, the father may inherit from his biological child. I want everybody to pay attention. This is the very important thing about there is not, but don't no call no man on earth your father, for there is but one Father which art in heaven. See, we're not supposed to be taking on that surname as a surrogate, an orphan. This is the correction of the record. You ain't my daddy. There's but one Father which art in heaven. And that's my legacy inheritance. What is it? Colossians 3:23 through 24. Whatever your task, work heartily as serving the Lord and not men, knowing that from the Lord you will receive the inheritance as your reward. So this is what I'm working on. Or wait a minute, we got one more. Goodness gracious, I didn't show you that one, did I? I'm sorry, I didn't switch my screen. But as you can see, there's more verbiage under the Father. And that's because there's an exception as to whether the father can inherit from his biological child. And that's if he makes the false claim to the surname, which isn't that of our Father which art in heaven. Isaiah 43:1, I fear not, for I have been redeemed. He has called me by my name. I am his. 44:1, Isaiah 44:5. One shall say, I am the Lord's. One shall call himself by the name of Jacob, and another shall subscribe with his hand unto the Lord, and surname himself by the name Israel. I don't know anything about your military formats and how you use that surname. It's quite confusing if you ask me. I mean, it seems very colorful, but I can't say for sure. All I can do is pose the presumption that seems to be paramount and patently observed as to what style fits what grammar. I've come to some kind of but I don't take my word at it. It's just my opinion. So when it comes down to the truth of things, I have to use the words of our Father which art in heaven. I can't use your grammars. I can't accept that some guy on this planet gets to claim fatherhood, like the Pope claiming he owns the souls of all men. You can't do that. That claim is already done. What is done is what ought to be done. There is nothing new under the sun. And again, I say, I fear not, for he has redeemed me. He has called me by thy name. I am his. There's nothing to question about that. So fuck you and your adoptive record and the biological father. That's not me. I'm a child of God. So let's take a look at the next one as it goes to their abuse and of position and conflict of interest. An employee shall not use or attempt to use his/her official position to secure unwarranted privileges, advantage, or exemptions for the employee or others. So when somebody, as a third-party debt collector, wants to come after you and make a claim in these courts, and these courts accept it, what they're doing is they're going to they're trying to say that they're using their official position to secure the unwarranted privileges, advantages of that third party of knowledge that you evidently don't have. They're using that against you. They're using the fact that you don't know that there's not an actual contract with this third-party debt collector, and that is the crux of the law, and how you point that out through the fact that, hey, they're making a judicial assertion through an administrative process, trying to stick to an administrative process without addressing the fact that there's no contract. And therefore, they have no private right of action in the administration known as the distribution of assets by accessing the estate for that reason. Again, there's no deceased. They have no authority to come after the estate of somebody who is in fact alive, because they need that estate as a necessity of life now. You cannot detract from that estate and take from their livelihood. Necessities of life are superior to all other claims and need not a commercial lien of any sort. Employees shall not use undue influence to gain or attempt to gain personal advantage or advantage for a family member or friend in the courts. No employee shall accept, solicit, or agree to accept any gift, favor, or anything of value based upon any understanding, either explicit or implicit, that the official actions, decisions, or judgment of any employee or official would be influenced thereby. Employees shall report to their supervisor any offer of a bribe or gratuity. No employee shall request or accept any fee or compensation beyond that received by the employee for any matter related to the employee's job. An employee shall avoid conflicts of interest or the appearance of conflicts in the performance of the employee's official duties. A conflict of interest exists when the employee's objective ability or independence of judgment in the performance of his or her job is impaired or may reasonably appear to be impaired. So if the employees of the court cannot read the plain writing that I put forth in a notice that I'm sending out tomorrow in relations to a court case for my companion, and a third-party debt collector making a false claim upon which relief cannot be had, then they're the ones that are going to have a little bit of an issue, because there is a conflict in the performance of their jobs to seem reasonably impaired. A conflict also exists when the employee or employee's family or business would derive financial gain as a result of the employee's position within the court system. So the one conflict of being impaired leads to another conflict because it's unjust enrichment by just doing your job, even though while you're impaired, because if you were impaired while drinking, they would not pay you. Yet here you are, you're impaired out of stupidity, and yet they're paying you. This is the financial director appointed by the United States President, Joe Biden, and doesn't know how the financial system works. Set it out in open international telecommunications, news networks around the world. I don't understand how it works. His words. Transacting business as an employee of the judicial branch with any business entity in which the employee has an interest is prohibited. Remember yesterday or the day before where we talked about the plaintiff having to put forth certain funds to fund the case, and that both parties may be required to do that, although it only takes one. See, they already have an interest with a business entity that paid to have something filed into the court. They already have an interest in a contract to do so. Employees shall not keep secret or unavailable information or records which are public or which rightfully should be furnished to government employees and the public. No employee shall intentionally alter, falsify, destroy, mutilate, backdate, or fail to make required entries. Fail to make required entries on any records within the employee's control as it goes to the integrity of the record and their competency and being not impaired to make sure ethically that that record is correct. And if you give them information that it's not, and they say, oh, well, I'm just doing my job, and they don't move further to make sure that the record is correct, that is their record within their control. Or give false information. This provision does not prohibit alteration or expungement of records or documents pursuant to law, court order, or court rule or court order. It's saying that you can alter or expunge records pursuant to law, court rule, or court order. This provision does not prohibit alteration. Remember, we talked about them swaps. That's an alteration. Pooling them, pooling all of those private investment assets as if though there's no value to them, or as if though they're required as a penalty for a prohibition that you offensively violated when all of it's false. No employee shall refuse to enforce or otherwise carry out any properly issued rule, directive, or court order, nor shall any employee exceed that authority. In other words, even their own job has an order behind it, and they're supposed to follow that. Are you familiar with the Judiciary Act of 1789? So let's go take a look at this document I wrote up. Where is it? Where is it? Here we go. Okay. Okay, everybody can see that. You got it. Let me get me out of here. Okay. What we got here is 17, 21, 33, 93, 20, which is an epoch number, which converts to this time and date right here. I do that for all my documentations. And then I leave this space up here for my own letterhead because I printed this with my letterhead on it. and this is for my companion with my letterhead. And so it says clerk of court and judicial officer, and I believe it should have been administrative law judge in there as well, but we can always correct it later if need be. This is a private special appearance on behalf of Joyce Schmidt. Private communication and not an entrance into any action. Answer in private for abatement. The court cannot obtain personal jurisdiction. Without personal jurisdiction, the court's subject matter and territorial jurisdiction cannot apply in this instance. Joyce retains the private right of settlement of the estate upon death. Joyce, family Schmidt, witness, docket number and then the case number, accused. See, we're not naming anybody. We're putting in a case number. Again, it's always the number. So we're going against the record as so enumerated. And this record so enumerated is what we're accusing to be entered in error. Failure of jurisdiction in all parts, territorial, subject matter, and personal. Joyce cannot defend in private status or capacity, retired and disabled as the record reflects. Joyce Schmidt is not an eligible contract participant. Citizenship and use status in error. Joyce lives at her pleasure now, not subject. No longer in residency of United States citizenship. Request for administrative review for 12B, failure to state a claim for which relief can be had. Sources not limited to 18 U.S.C. 7, 8, and 9 as it relates to the special maritime territorial jurisdiction for obligations and other securities of the United States by vessels of the United States so assigned as citizens or officers. 48 CFR 1652-370, use of the matrix as it goes to disabled as it relates to health and human services, healthcare. And then 48 CFR 2152.37, use of matrix, retired as it relates to the life insurance program. This writing is to forewarn the appropriate contracting participants that the claim of debt as a private right of action suffers fatality for lack of proper interest. These matters are brought by a third party not initially interested. These matters are brought after the original contract was charged off pursuant to the original creditor's request, as the record will reflect. In other words, the original creditors secured that contract, as we saw earlier, and these plaintiffs have no right to secure it again. That's double jeopardy. It was already charged off by the original person or party, the original creditor that charged it off. They already made the claim of a loss, and it was charged off through the IRS. This event here creates another taxing event on the same money. Double jeopardy again. No, you can't do that. That's a false claim for unjust enrichment. Let's see here. What else? Where are we at here? The following admissions will show the fatality of the claim made by plaintiffs as unlawful interveners using a law or legal process whether administrative, civil, or criminal, in any manner or for any purpose for which the law was not designed, in order to exert pressure on another person to cause that person to take some action or refrain from taking some action. These actions may result in fines and possibly imprisonment of not more than 20 years or both. See 18 U.S.C. 1589, forced labor. This court, in other words, they're trying to force contract when there is no contract. Understand that. This court's actions upon such a claim will lay the court in culpability as conspirators with the plaintiff as officious intermeddlers acting executor des tort. These actions are contested as a matter of Scott versus McNeil, in that the court of probate or otherwise have no jurisdiction to appoint an administrator to probate the estate, or probate of an estate of a person who is in fact alive. Also see Hogan versus Jackson. The words real and personal effects will embrace the whole estate. So for the plaintiffs, Portfolio Recovery Associates, LLC, admit or deny. Circle 1. The record does have evidence, in fact, that Joyce is a resident in the state of Iowa. Yes or no? They don't truly know the answer to that. But if they answer, they'll answer yes. They're going to claim yes if they answer. The original creditor is Capital One. Of course, they've already admitted that. All parties admit that Capital One is the original creditor. That's who secured the contract. Joyce signed a contract with Portfolio Recovery Associates, LLC. Yes or no? They cannot say yes. They must say no, and this debunks their whole case under common law. Under administration, it would go on as if though there is a contract, because you don't rebut the fact that there's no contract. Portfolio Recovery Associates, LLC has a private right of action. Again, if they answer, they're going to claim this, but they can't without a yes here. And they can't have a yes here because simply buying the contract from somebody else and presuming that we now have a contract with LLC is nothing but evidence that they merely purchased a contract that has already been charged off and secured. They can no longer secure it. It was already secured and charged off. All they can do is make a claim that, hey, you didn't pay this debt, and make a claim of salvage of the debt. Well, that's easy. I want to cancel the debt. Joyce is a resident in the state of Iowa is the problem that they're going to have to bring that suit in any case. This is just like defendant. It's an abstract noun. It doesn't mean shit. It's total presumption. And then down here, instead of putting signature or anything, it's witnesses. Reverently, Chaplain Keith, Life Estate Trustee for Joyce. And again, we're talking about common law where there's got to be a contract. My companion and I have a contract. It's known as a living will. She's assigned me as the power of attorney in case she can't make decisions according to her life estate. And being that she's resigned, retired, and disabled, whatever you want to call it, that's admittance herself of being incompetent of managing those affairs and doing things at her pleasure. That's why I'm happy to take over for her. While other people claim that I'm living off of her. Pathetic. In Ecclesia, Sister Joyce, she's no longer taking upon any titles. She's in her rightful post in life now. Sister Joyce, Life Estate Benefactor. Anyway, that brings us to the end of our stream here for tonight on probate. and what we're doing in regards to this stuff. And again, like I said, this is what I'm doing. I'm not saying it's a course of action for anybody else. I'm showing you what I am doing, and I'm giving you the results. Just like I showed you what I did with the court of probate, or the failure to appear for jury duty, and how that was done. And now I move forward with the tort claim because the dummy insisted that they're going to costs are taxed to the defendant. Again, still claiming that somehow they have personal jurisdiction to administrate that estate and place such a false order. I don't know what they don't understand about plain writing. They don't have any power from anywhere. I don't care if it's a tax court or a probate court. They don't have any power to appoint the administrator of an estate of somebody who's in fact alive. That's forced contracting. You can't do it. So anyway, I want to remind everybody, please hit that like, share, and subscribe button. And as always, I don't get many donations, and they're always appreciated. Every little bit counts. So be sure to hit that PayPal button and share some love. And you guys know me. I love you. But I don't give a rat's ass whether you love me back. And that's to say, I don't care if you hate me, and I don't care if you don't respect me. That's on you. So may God bless you, and have a good night. We'll see everybody next time. Bye now.